As you all know, domestic violence is a crime of violence. It is a crime of power, a crime of dominance. And while it is not only women who are victims and who are impacted by domestic violence, they often constitute the largest group of victims, while perpetrators are predominantly men. Again, while victims of domestic violence find it extremely hard to access the legal system in any context, the structural and institutional barriers that are faced by them increase a lot when they belong to socioeconomically marginalized communities. So class, caste, religion, race in other contexts and countries all lie at the very heart of the challenges that are faced by victims of domestic violence in trying to access justice for themselves. Now, just moving on from that, it's important to understand what violence against women and domestic violence means. And I'll be sharing a short presentation with all of you to just walk us through some of these key concepts and understand how they've been dealt with across the world, and particularly in India. Yeah. So the meaning of domestic violence is, as has been given by the United Nations Declaration on the Elimination of Violence Against Women. Violence against women means any act of gender-based violence that results in or is likely to result in physical, sexual, or mental harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in the public or in the private life. Intimate partner violence refers to behavior by an intimate partner or an ex-partner that causes physical, sexual, or psychological harm, including physical aggression, sexual coercion, psychological abuse, and controlling behaviors. So extremely, extremely important to note that it is not just physical and sexual violence, but also mental and psychological harm that has been recognized to be domestic violence or intimate partner violence across different contexts. As I mentioned, there was a rampant surge in domestic violence incidents amidst the lockdown. And since the outbreak of the COVID-19 pandemic, they went up by about 20% in Argentina, 25% in the UK, 33% in Singapore, 30% in France, and a substantial increase in India as well, where the National Commission for Women received 123 complaints pertaining to domestic violence just between the 23rd March 2020 to the 10th April 2020, which is when the first lockdown was announced in the country. Several informal organizations and helplines also reported a surge of over 80 to 125% across countries of incidents of domestic violence that were reported. Now, speaking of incidents of domestic violence in the WHO, the WHO's 2005 multi-country study on women's health and domestic violence against women confirmed that among women who'd ever been in an intimate partnership, 13 to 61% reported ever having experienced physical violence by a partner. 4 to 49% reported having experienced severe physical violence by a partner. Sexual violence rates were extremely high as well. And so was the case when it comes to people who've been at the receiving end of an emotionally abusive act from one or more partners in their lifetime. Similar surveys have been conducted in India as per the National Health Family Survey 4, which pertained and was conducted in the year 2015-16. 31.1% of married women experience spousal violence in their lifetime. That's nearly 1/3 married women in the country who were a part of this survey said that they've experienced spousal violence in their lifetime at some point or the other. 24% had experienced spousal violence just in the last 24 months. Now, speaking of the kinds of spousal violence that exist, percentage of ever married women aged between 15 to 49 years who had experienced spousal violence of different kinds and specific acts are seen from this graph. Women who were pushed, shook, threw something at, their arm was twisted, their hair was pulled, women who were slapped. These show extremely high statistics of women who'd faced these specific acts ever, but also particularly so in the last 12 months before the reporting. Now, one of the key questions that we ask ourselves often is, why is there such a high rate of domestic violence in the country? 52% women and 42% men believe that domestic violence was justified for any of the following reasons. A woman goes outside the house without informing the husband. As you can see, this is seated in a very, very patriarchal mindset. Woman neglects the house, the children, or household chores. Woman argues with the husband, refuses to have sexual intercourse with the husband. So needless to say, no recognition of sexual autonomy whatsoever. A woman is suspected of infidelity, and a woman is considered to be disrespectful towards her in-laws. Now, one of the things to note when we're looking at these numbers, which is 31.1% married women having experienced spousal violence in their lifetime and 24% in the last 12 months, is that this just forms a tip of the iceberg. And I say that for several reasons. First, this survey is only limited to married women. It doesn't even cover others who live with their intimate, who suffer from intimate partner violence and might be in other kinds of relationships which are not marriage. The age group of people who were surveyed was between 18 to 49 years. And there are a lot of biases that creep in if this survey is taken in the presence of other members of the household. More recently, the National Health Family Survey 2019-2020, phase 1 has also been completed. And as you will see, the bar to the left shows the figures from the 4th survey, while the bars towards the right show the figures from the 5th survey. And there has been a huge increase in several states. So for instance, state KA, Karnataka, you see that under the National Health Family Survey 5, 44% married women reported having experienced spousal violence at some point in their lives. So that's nearly half the women who formed a part of this survey. The other question to consider, and that's extremely compelling, is the underreporting of incidents of domestic violence. As I mentioned, this is a trend that is extremely prevalent across the world and not just in India. But some of the statistical reports that have come out show the extent to which domestic violence incidents are not reported. So you'll see to the left, Section 498A, NCRB 2019. Section 498A of the Indian Penal Code is a criminal law that protects married women from their spouses as well as their spouses' relatives. The NCRB, which is the National Crime Records Bureau of 2019, gave a report of the number of complaints that had been filed under this criminal law of Section 498A of the Indian Penal Code. And to the right is the National Family Health Survey 5, phase 1, which is the statistics that we just saw. You will see that the bars to the right are much bigger and broader than the ones to the left. This shows that while a lot of women in the National Family Health Survey reported having experienced spousal violence in the past or in the last 24 months, these do not often fructify in any sort of complaints that are filed against spouses or spouses' relatives. Now, just to note that even with this mismatch, which is the NFHS data being way larger in terms of percentages as compared to the NCRB data, the NCRB data actually has a much wider net in that it is not confined to women who belong to the age bracket of 18 to 49, and it is not confined to people who've reported spousal violence. So even women who've not filed cases against their spouses, but have filed cases against their spouses' relatives are included in those blue bar graphs that you see. This is extremely, extremely troubling because it is indicative of the massive underreporting of incidents of domestic violence that is occurring in the country as recently as 2019-2020. Now, the question that arises in India, as also across the world, is why are domestic violence incidents severely underreported? Naturally, there is often fear of retaliation, both from the spouse, also the spouse's family, very often your own family, which brings us to the next point, which is often you suffer from lack of support from your family as well as your friends. You don't have enough people who would walk you through the system. There is still a lot of stigma that is associated with filing domestic violence complaints, which makes it harder for people to go ahead and file complaints. There are lack of alternative means of economic support, given that a large section of the society is still structured in a way where women are expected to give up on full-time jobs, not pursue their careers, pursuant to having gotten married. There often is financial dependence on male counterparts, which makes it harder for women to access justice and file cases against the spouse. Very often, you worry about losing your child's custody without having all the support that is required to pursue litigation and to pursue a domestic violence complaint against the spouse and the spouse's family. And lastly, a lot of people, women alike, believe that your partner will change. Conversations with the partner may change, because of which you often don't end up filing domestic violence complaints. Of the 31.1% women we saw in the NHFS survey 4 of 2015-16, 75% did not seek help from anyone whatsoever. There was an extremely interesting ethnographic study that was conducted by Ms. Sriparna Chattopadhyay. It's called the Pyramid of Reporting, and it analyzes the manner and the modalities that are involved in somebody reaching out for help once they've been a victim of domestic violence. And it said that there is a pyramid of reporting where informal sources, which is your natal family followed by friends, are often favored as sources as compared to the institutional routes that are available to a victim of domestic violence. So that could be a non-governmental organization, that could be the police, that could be the court system. So you're very often inclined to go to family and friends and asking them to intervene rather than go through the formal course. Lack of reporting also means it in turn contributes to this vicious cycle where it perpetuates silence and stigma around domestic violence. And then other women find it hard to come out with their situations and the domestic violence and the intimate partner violence that they face in their lives. The question of why domestic violence incidents are underreported was recently discussed in 2018 in a landmark judgment. The name is right here on the screen. Bhartiben Bipinbhai Tamboli versus State of Gujarat and others. And I'll just read the extract, which is compelling and sums the issue up. The domestic violence in this country is rampant, and several women encounter violence in some form or the other, or almost every day. However, it is the least reported form of cruel behavior. A woman resigns her fate to the never-ending cycle of enduring violence and discrimination as a daughter, a sister, a wife, a mother, a partner, or a single woman in her lifetime. The non-retaliation by women, coupled with the absence of laws addressing women's issues, ignorance of the existing laws enacted for women, and societal attitude makes the woman vulnerable. The reason why most cases of domestic violence are never reported is due to the social stigma of the society and the attitude of the women themselves, where women are expected to be subservient, not just to their male counterparts, but also to the male's relatives. Now, this brings us to the important question of what is the statutory framework in India that protects the right of women, particularly victims of domestic violence. So the Protection of Women from Domestic Violence Act was enacted in 2005. It has an extremely broad definition of what domestic violence entails. I'll just read it for your benefit. Domestic violence is any act, omission, conduct, or any threat by the attacker towards the victim or a relative of the victim. So it could be the victim herself or a relative of the victim, which harms or endangers the health, safety, limb life, harasses, harms, injures, endangers for dowry, results in any physical or mental harm. Extremely important, as I mentioned before, domestic violence includes physical abuse, it includes sexual abuse, verbal and emotional abuse, and also economic abuse. So deprivation of financial resources would count as domestic violence. This is particularly significant in the Indian context, like I mentioned before, where a lot of women are expected to or not given the opportunity to pursue their professional path and build financial independence for themselves and end up being dependent on their male counterparts. Now, obviously, the important question to consider is who can file a complaint against the Protection of Women from Domestic Violence Act. This has been provided for in the legislation itself, where an aggrieved person is any woman who is or has been in a domestic relationship with the respondent, which is the perpetrator, and who alleges to have been subjected to any act of domestic violence by the respondent, which is such perpetrator. Obviously, the question that arises is, what is a domestic relationship? Given that an aggrieved person can only be one who's been in a relationship, which is a domestic relationship. A domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household, where they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together is a joint family. So, as you can see, the definition of a domestic relationship, where you ought to have lived in the same house and be related by all of those criteria that I mentioned above, shows that it is not just restricted to spousal violence. So a woman who's been in a live-in relationship with a man falls under the ambit of the Protection of Women from the Domestic Violence Act. You could be filing a case against your father. You could be filing a case against male relatives of your partner or your spouse, or female relatives of your partner or your spouse. So all of these category of women are entitled to protection under the Protection of Women from Domestic Violence Act. Who can be a respondent under the Domestic Violence Act? Now, a respondent, as it was defined in the Act, was any adult male person who is or has been in a domestic relationship with the aggrieved person, the definition of which we just saw, and against whom the aggrieved person has sought any relief under this Act, provided that an aggrieved wife or female living in a relationship in the nature of marriage may also file a complaint against a relative of the husband or a male partner. Now, you'll notice that this definition clearly says that a respondent is any adult male person. The question that arose before the Honorable Supreme Court of India is that, does this mean that female relatives of a male partner or a male spouse are excluded from the ambit of who is a respondent under the Protection of Women from Domestic Violence Act? This came up for consideration first in 2011 and then more recently in 2016, where the Supreme Court clearly held that the definition of respondent, although says any adult male person, does not exclude female relatives of the husband or the male partner from the ambit of the Act. So today, your male spouse's mother could be a respondent under the Protection of Women from Domestic Violence Act. In 2016, in Hiral P. Harsora versus Kusum Narottam Das Harsora, the Supreme Court took a further step by clarifying that such female relative, so your mother-in-law, for instance, or your sister-in-law with who you've been in a shared household in a domestic relationship, can still be a respondent or a perpetrator even without your husband being arraigned as such. So even without the adult male member being implicated. Now, the Protection of Women from Domestic Violence Act has been a step forward in India in terms of the ambit and the kind of reliefs that it offers to victims. So you see a couple of them on your screen. You are entitled to protection orders, residence orders, monetary relief, custody of your child, compensation orders, and other interim and ex parte orders. I'll just briefly discuss these, and then we can speak more about this in the Q&A section if any of you is interested. So protection orders, if there is any apprehension of any harm of any nature being caused to you, to your child, to your relative, then you can go before the magisterial court under the Domestic Violence Act as a victim of domestic violence, express that apprehension and seek protection from the court. Very often, you will be allocated what is called as a protection officer, who is an officer who's been deputed by the court to look after your welfare. And you will often make a call to that protection officer if that threat manifests itself. Residence orders, like we mentioned, a lot of times, especially in the marital context, women often end up being dependent on their male spouses or partners for residence. In which case, in a situation of domestic violence, if either a woman has been forced to leave the house or has been evicted from the house, then the victim can go to the court and spell out the need for residential relief, and that residential relief is granted by the court. Monetary relief. In the event that your familial life has been structured in a way that the male member has been looking after the needs of the child or the needs of the family or the needs of the victim, then you can seek monetary relief and ask for maintenance, including during the pendency of the litigation. The test being that a woman should not be compelled to live a life of vagrancy by virtue of being a victim of domestic violence. So she's entitled to the same kind of lifestyle that she was used to prior to the separation or prior to her eviction or prior to her being forced to leave the house. Custody of the child, like we discussed some time ago, very often women worry, victims worry that they will lose the custody of the child if they're forced to leave the house, or male counterparts will come and forcibly take the child away. So on the first day when you go to court or in the life of the litigation, you can ask for protection of the custody of the child. Compensation orders for the harm that has been caused to you and for the pain that you've been through as a part of the domestic violence that has been perpetrated against you is another relief that you can seek before the domestic violence courts. Section 498A of the Indian Penal Code. I briefly flagged this while we were comparing statistics of underreporting. Unlike the Protection of Women from Domestic Violence Act, which has both a civil and a criminal component, Section 498A finds its place in the Indian Penal Code, which is a criminal law. It is to protect married women from cruelty by the husband or relatives of the husband. I'll quickly read this for you. Whoever being the husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and also be liable to fine. Explanation. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health. Importantly, whether mental or physical of the woman, or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. So a woman could go under the Protection of Women from Domestic Violence Act, or a woman could file a complaint under Section 498A of the Indian Penal Code after having been subjected to domestic violence. Now, at this point, I think it would be relevant to just understand the practical application of the Protection of Women from Domestic Violence Act in India. Like I said, the act is a broader framework of protection than what women had before this act came into being. But it continues to have certain issues given the context in which we're operating. I don't think there's a way for all of you to interact with me through this, but I strongly encourage all the attendees to look at these illustrations with me, make a note of the answers, and then I'll walk you through the answers and we can have a conversation about any doubts that you might have on these illustrations towards the end of the session. So Rishi and Reena were working together. Rishi, 32, has 2 children, and though not divorced, so he's not legally separated, is separated from his wife, while Reena, 33, is single. Rishi and Reena fall in love. Reena, being fully aware of Rishi's marital status, quit her job and started living with Rishi. As a modern couple, they started a joint account where they contributed resources commensurate to their respective financial positions. They even started saving money to invest in a joint property. The 2 times that Reena got pregnant owing to contraception failure, Rishi asked Reena to abort the fetus. Although Rishi's refusal to let Reena add his name as a suffix was always a sore point between them, they had a happy relationship. 4 years later, though, Rishi evicted her from his house. The question is Reena, the victim in this situation, entitled to any remedy under the Protection of Women from Domestic Violence Act or the DV Act? While you're all contemplating the answer, the question lies in whether Rishi and Reena were in a domestic relationship. So we know that they weren't in a marriage, but were they in a relationship in the nature of a marriage, which would determine whether a victim is entitled to relief under the Protection of Women from Domestic Violence Act or not. In the judgment D. Veluswamy versus D. Pachamal, the determinants that were laid out for stating what the relationship in the nature of a marriage would entail is: 1, both the parties must behave as husband and wife and are recognized as husband and wife in front of the society. They must be of a valid legal age of marriage. They should qualify to enter into a marriage. For instance, none of the partners should have a spouse living at the time of entering into a relationship. Now, bear in mind, this criteria is important because we just saw that while Rishi was living with Reena, but he wasn't yet divorced. So he did have a spouse living at the time of entering into the relationship with Reena. They must have voluntarily cohabited for a significant period of time, and they must have lived together in a shared household. These determinants have further been culled out in another leading judgment of Indra Sarma versus VKV Sarma. Again, much like the previous judgment, you have to look at the duration of the period of the relationship. You have to see whether they lived in what is called as a shared household, whether there was pooling in of resources and financial arrangements. We saw with Rishi and Reena, there was a joint account and they used to spend monies from that joint account. What the domestic arrangements look like, whether they had any children, whether there was a sexual relationship between the two, what their socialization and public holding was, whether they held out to be each other's partners, and what was the intention and the conduct of the parties. The important thing to recognize is that you're still looking at this at the bedrock of a marriage and then seeing whether it's a relationship in the nature of a marriage. A relationship in the nature of a marriage, or what would amount to a relationship under which you'd get certain reliefs, has been dealt with in several legislations. It's been looked at in the UK, in Scotland, and Canada. I won't delve into each of these, but for those of who you're interested, the relevant laws to look at have been stated on this slide. Moving on to another illustration. And this deals with the concept of residence orders that we just discussed and the concept of a shared household. So Urvashi and Manik had an arranged marriage in 2008, which was a marriage that has typically been arranged for by the families. Pursuant to their marriage, they both started residing in the husband's parents' house, which was a flat in a posh locality in New Delhi, which was owned by the husband's father, so by the father-in-law. Both the wife and the husband, which is Urvashi and Manik, had a daughter in 2013. She left her job after she conceived the child. However, Manik has been doing extremely well professionally. Since Manik is the only child and he's aware that at some point his father will give him the posh flat, he either puts his savings in fixed deposits or in commercial properties. By 2015, he starts taunting his spouse about eating up her resources, calling her inadequate, and substantially reduces the money that he gives to her. So, like we discussed, there is increased financial deprivation of resources that is happening. During the summer vacation in 2019, the wife and the party's daughter go to spend a week with her mother in another city in Mumbai. On their return, they're not allowed to enter the house in which they've been living through the marriage. The question is this blocking of financial resources and being evicted out of the house in which you've been living throughout this period, does that attract the Domestic Violence Act, and do you become entitled to any residential relief and residence order under the Domestic Violence Act? The thing to consider here is whether your residence, your posh flat in the Vasant Vihar locality constitutes what is called as a shared household or not. A shared household has been defined under the Protection of Women from Domestic Violence Act as a household where the person aggrieved, in this case Urvashi and their daughter, lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent, or both jointly or singly, have any right, title, interest, or equity, and includes such a household which may belong to the joint family of which the respondent, which is the husband in this case, is a member, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the shared household. Now, this is a bit of a long definition with lots of layers to it, but it would include a property which has either been rented out by the husband or the wife in this case. If the husband forms a part of the joint family to which this household belongs, even if it is not in the name of the husband. So a residential relief is usually pegged at a house in which you've stayed through the marriage, or the last lived house of the parties. There was a judgment in 2007, which has recently been overturned by the Supreme Court. The judgment that existed earlier, S.R. Batra versus Taruna Batra, said that as regards Section 17(1) of the Act, which is the residential relief, it would be in this case, in our opinion, the wife is only entitled to claim a right to residence in a shared household, and a shared household would only mean the house belonging to or taken on rent by the husband, or the house which belongs to the joint family of which the husband is a member. The property in question in the present case neither belongs to Amit Batra, who was the husband in that case, nor was it taken on rent by him, nor is it a joint family property of which the husband is a member. It is the exclusive property of the mother of the husband. Hence, it cannot be called a shared household. So just going back to our illustration, if we were to apply the S.R. Batra versus Taruna Batra logic, I draw your attention to the last line. It is the exclusive property of the mother of the husband. Hence, it cannot be called as the shared household. Going back to our illustration, you will note in the second line that this property was owned by the husband's father. Now, we have a peculiar situation under the Tarana Batra formulation where a woman has lived throughout her married life in a particular house that has been provided by the husband. Yet there is a judgment that says that if that house belongs to the husband's relative and not to the joint family, then a woman does not remain entitled to any residential relief. Thankfully, this was recently overturned in a judgment called Sneha Ahuja versus Satish Chandra Ahuja, which is recognized that if you've lived in a house throughout, then that has to be accounted for. And Tarana Batra has been set aside. Now, another illustration to account for is what happens in cases where cross-border issues are at stake, where couples have traveled outside of India, but after domestic violence is perpetuated or there's an incident of domestic violence, a woman is compelled to travel back to the country. Abhishek and Shweta got married according to Hindu rites, ceremonies, and customs in New Delhi in 2014. Within a week of their wedding, both went to the husband's house in Dubai. Within a year of their marriage, the husband subjected Shweta, the wife, to physical violence. By 2017, he stopped interacting with the wife at all and was having an extramarital affair. Finally, by 2019, I'm so sorry, Shweta was constrained to come back to Delhi, where she initiated proceedings under the DV Act as well as for divorce. In both these proceedings, the husband filed his written statement, which is his response to the petitions, contending that he did not subject Shweta to any cruelty or any desertion whatsoever. Pursuant to that, he filed divorce proceedings as per Shariat law in Dubai. So, given that Shweta only ever resided in Dubai, will her DV complaint be maintainable, or is a court in Delhi, does a court in Delhi have the territorial jurisdiction to deal with it at all? Or will she be compelled to go and contest the proceedings in Dubai? This becomes extremely important in what the National Commission for Women would call NRI marriages, which is a lot of people travel outside the country pursuant to their marriage and then rely on that as their network and their social support. So the judgment of Indra Sonti versus Surya Narayan Murthy Sonti said that desertion by an estranged spouse, who the other, is a continuous act. And as such, this conduct was continuous unless it was stopped by the deserter. So in this case, Abhishek having stopped all contact with Shweta or having had an extramarital affair is an act which continues and travels with the woman when she comes back to the country. So cruelty has been interpreted in a way that as a victim of domestic violence, when you move from place A to place B, unless the cruelty has been condoned by the victim, or unless there's been an end that has been put to that cruelty travels with the woman. So under Indra Sonti, given that the desertion would travel with the victim when she comes from Dubai to India, a court in India and a court in Delhi would have the jurisdiction to deal with her complaint. The second question is, if there is a foreign judgment, then how do you recognize, or on what basis do you recognize that foreign judgment in India? In Y. Narasimha Rao, which is the leading Supreme Court case, the Supreme Court held that for a foreign judgment to be recognized, it must satisfy Section 13 of the Civil Procedure Code in India. And an important requirement of Section 13 of the Civil Procedure Code is that the foreign judgment must have dealt with the facts on the merits of the case. And it can't just be a procedural thing. You have to appreciate the Indian law in question and deal with the fact situation on the merits of the case. Lastly, Modi Entertainment Network versus WSG Cricket lays down the guidelines and principles for grant of what we call is an anti-suit injunction. So you would typically come to the court in India and tell the court that the appropriate jurisdiction to deal with the case is the Indian court, and ask for an anti-suit injunction to say that you would not be participating in the foreign court. So Shweta would move the court and say that the forum convenience, or the convenient forum for the parties, particularly in light of the cruelty traveling with her, would be the court in India. And this would include questions of whether the defendant, in this case the husband, is amenable to the personal jurisdiction of the court or not. Like I mentioned when we started, this conversation would be incomplete if we didn't look at the impact that the COVID-19 pandemic, particularly the lockdowns that have been imposed across the world and in India, have had on domestic violence. So, as you all must be aware, UN Women has termed increasing violence against women amidst the pandemic as the shadow pandemic. The global cost of violence against women has previously been estimated at approximately 1.5 trillion US dollars. There's been a massive increase in abuse-related searches on the internet in the last year and a half. There has been an increased recognition of inability of victims of intimate partner violence and domestic violence to even make phone calls on helplines across the world, or to family and friends by virtue of the lockdowns. And extension of helplines, psychosocial support and online counseling using technology-based solutions such as SMS, online tools and networks has gained increased popularity in the last year and a half. This question is particular in my slides to India, but I'd love to hear your thoughts on the different contexts in which this question plays out, which is, what are the causes for increase in domestic violence during the lockdowns that have been imposed? So there has been increased confinement with your perpetrator, which has led to an increase in incidents of domestic violence. Very often people have had to participate in domestic chores, which has led to greater incidents of domestic violence. Unemployment or the economic stresses that have been caused by the pandemic have been recognized as another cause for increase in domestic violence during the lockdown. Excessive alcohol consumption, after which the incidents have gone up. Ironically, the inability to get alcohol has also led to an increase in domestic violence cases. Like I mentioned, not being able to call family, not being able to call friends, so inability to access family or friends, inability to access police, courts, or counselors for a long period in the country, in India, including in Delhi, in the courts in Delhi where I practice. It was extremely hard, even in your most urgent matters, to be able to move to court for your reliefs. There was an attempt to try and deal with these matters on video conferencing, but to be able to speak with the registrar and the administrative department of the court to try and get a matter listed. Then for the learned judge to be able to sit, to coordinate with their staff for any sort of orders to be passed, was extremely difficult and rare amidst the peak of the pandemic. And the legal recourses that were available at the time. You could reach out to the police, you could reach out to the National Commission for Women, State Commission for Women. For instance, the Delhi Commission of Women had a very active helpline to help women and victims of domestic violence. Shelter homes for victims is another idea that was discussed amidst the pandemic. Access to courts, but like I mentioned, there were severe restrictions on those. NGOs and other support organizations. And one of the attempts that was made was to characterize people or victims who are facing domestic violence as needing access to essential services during the pandemic, because all other services were blocked during the lockdown. So these were a bunch of aspects to consider on domestic violence in the Indian context. I'll turn over to Felicia, and I'd love to hear questions and comments from all of you.